Welcome to the District Court Show. This is a production of the 10th Judicial District. I'm Judge Steve Halsey from Wright County. My co-host is Judge Elizabeth Strand. She's also from Wright County. And the topic of this program is going to be Minnesota child protection. We're going to focus a lot on changes that were made by the legislature to the law and procedures in the last session, and Judge Strand's going to introduce our guests.
It is my pleasure to introduce Suzanne Tuttle and Zimmerman to our show today. Suzanne is a licensed social worker. She has been a social worker in child welfare services at Anoka County for over 22 years. She has served as a former supervisor there and is presently the manager of Children and Family Services. Welcome.
Thank you.
We also have Ann Zimmerman, as I stated. She served as an unemployment law judge for some time, for about 6 months, and then delved into the world of being an assistant county attorney, where she worked in Chisago County for about 4.5 years, doing primarily juvenile work, and presently works as an assistant Anoka County attorney. She's worked there for 8 months in the juvenile division. Her primary caseload is with child protection. Welcome.
Thank you.
We'd like you to each describe what your roles are in child protection cases. And Suzanne, why don't we start with you?
Well, my role is I manage the Children and Family Services area, which is child protection screening, investigation, family assessment, long-term services, permanency and adoption, and foster care. And with our new staff that we'll talk about a little bit later, we have about 90 staff in Children and Family Services.
All right. And Ann, why don't you describe what you do as an assistant county attorney?
Sure. So in addition to the court processes that we become involved in, we're also typically staffing cases with social workers, both at the beginning stages, when a case actually is screened in for court purposes, and at the permanency stages when we're looking for a final option for children. So we're involved at every stage in child protection.
Okay, Beth.
Along with the recent changes this year, there's been a lot of information in the media about child protection laws. So there is a change in what can be considered in screening in, and perhaps we can talk about what screening in or screening out means. But there have been changes about screening cases in and what can be considered. So could you talk about that?
Sure. Do you want me to start a little bit with the process?
Could you?
So we get a report, and they are sent to the child protection screener. The reports come mostly from mandated reporters like schools, hospitals, teachers, the police, but also from neighbors and family and exes. And then the screener takes the report, and they now can look at all the past history, including previous screened out reports. And then they make a decision as to whether to screen in or screen out a report based on statute. And if they screen it out, they document it and close the case. And if they screen it in, it's referred to one of two tracks, either investigations, that would be for the most egregious types of reports and sexual abuse, and the other track is family assessment, and that would be for the less severe cases. So in the past, the screeners used to be able to look at everything that we had, information that we had on a family, and then a few years ago, we were directed by DHS that we could only look at the current report and not, go back and look at what we had previously. The new change is that we can now consider all that information, and we're happy about that change.
And you mentioned exes, which is a lot of people that we see, going through family court, and there's contentious child custody or parenting time disputes, and a lot of those folks end up making reports. If those are, well, first of all, if they are screened out, do you tell the person that's a reporter what the result was of your investigation?
No. Until the changes that are coming up, which, just as a reminder, they're not going to be effective until January 1st, and we don't know for sure exactly what the changes will be, but we're pretty sure. But the non-mandated reporters didn't get all that information. They would typically be told if we could screen it in or screen it out. But the mandated reporters would get a little bit of information, but now with the changes, they'll get more information. They'll know if it was screened in or screened out, if the family was referred for services and that type of thing. So they'll get more information.
Okay.
With these changes now, do you have to confer now with more with the county attorney's office? Do you get more communication now with other departments?
We are, I think our division always had a good relationship. If it was one of those high-risk cases, the staffing occurred even though we weren't statutorily obligated to do so. But now the statutes have changed, and it's very explicit. If you have a family assessment case where services are recommended, voluntary services are open, and they close either due to non-cooperation by the family or other circumstances, they are mandated to then staff it with us for the potential of a court-involved petition being filed.
And could you explain what happens when you decide to file a petition?
So if we do decide to file a petition after staffing, the social worker refers up a lot of information to us based on either their investigation or their voluntary work with that family. We then create a petition based on those facts, alleging certain information, and then the statute tells us what cases allow us to get involved based on their definition of what a child protection case is. We file that petition, and then we have court hearings, multiple hearings, to determine both what services are needed and whether the court needs to be involved.
And the acronym is CHIPS, and what does that stand for?
Child in need of protection or services.
And that used to be called child neglect, I think, in the old days. And so that's what your petition is for that type of proceeding.
Most petitions are. There are also petitions for termination of parental rights that the statutes sometimes require us to file, we say right out of the gate, meaning immediately. And those cases are less frequent, but they are occurring more as we get more reports and things occur. We are seeing a rise in that, at least this year we are.
Talk a little bit about what's an emergency protective care hearing. When you get a report of some serious, investigation and the children are immediately taken out of the home, how that process goes.
So in Minnesota, there are two methods of doing that, either by court order or law enforcement can place a hold on a child for 72 hours. Mm-hmm. And that's what we call then the emergency protective care hearing, is that hearing before the judge immediately or within 72 hours after that child is removed to determine whether that child remains out of home or goes back home.
Okay. Then you make a recommendation on behalf of the petitioner as to whether the child goes home or under what conditions or remains in foster care, correct?
Correct.
And how do you make that decision as to what you're going to recommend?
It's a collaborative effort with social services. Sometimes it came out of a family court case, so there might already be a guardian ad litem who's also involved, but typically it's a collaboration with that social worker who has really had a better hand on what is going on within the home to make that recommendation.
Okay.
How oftentimes are cases recommended for petitions, or that the two of you confer and a CHIPS petition is filed? Do you know?
Well, I'll just tell you some general numbers. We get about 3,000 reports of maltreatment every year.
And you say you, meaning?
Anoka County.
Okay.
Thank you. And we screen in at this time about 1,000 of those, so about a third. And then we end up, after the assessment or the assessor or the investigator goes out and meets with the family, they often determine that the family doesn't need a lot of services and they may refer to the community. But we end up opening about 200 to 300 cases per year, and that can range anywhere from a very short-term type of service to a much more intensive long-term court-ordered type of service. So maybe, it used to be maybe 50% of it's typically the investigative cases because those tend to be the more egregious cases. I would say maybe it used to be 50%, then it kind of went down over the years to maybe around 30%. And this year, I think partly with the more reports that we're receiving and the impact already from the task force, that it's probably 50% again.
Okay. And so we have the EPC, and let's assume that the process is going to proceed from there. There's then an admit-deny hearing after that, correct?
Yes.
And the parents typically get a court-appointed attorney, or they can hire a private attorney. They may admit the petition. Generally speaking, I think they usually deny the petition. And then what happens from there, Ann?
Usually it sounds a lot like a criminal case. It's set for a pretrial and then eventually a trial on the case. And at that point, a lot of it's discussion with the attorneys for their counsel. Guardian ad litem is always appointed, at least in Anoka County, right after the EPC hearing. So the guardian ad litem gets into the home, meets with the parents, meets with the children if they're of sufficient age, and also starts making recommendations, which I think sometimes helps resolve cases as well. If not, then we go to trial and the court ultimately decides if this is a child in need of protection or services.
Do you have any estimate that you can really make today about how many of the cases are settled at or before pretrial versus going to a trial?
I think the vast majority in Anoka County, I would say at least 70% are settled at the EPC or admit-deny hearing. I think part of that, though, is what Suzanne talked about earlier. It's a pretty narrow funnel before you actually get to the court process. So you're really seeing those cases that need the intervention by the time you get there. And a lot of parents recognize when they need that help, when it's all written down in paper and their attorneys meet with them.
And if the parents voluntarily submit to services, is there any need to file a CHIPS petition, or are they just provided with those services?
Most of the time, if they've agreed to services, it works out pretty well. Sometimes you work with the family for a while and then find out more information and find out that things are more egregious than you originally thought, or something may happen in the meantime too that raises it up a level so that you need to bring it into court. But typically, once they've agreed to voluntary services, most of them follow through with that because, like Ann said, they want the best for their child and they recognize that if it's gotten to this level that there needs to be some intervention.
And Ann, do you have any guess as to how many cases move on to the termination of parental rights phase?
I don't have exact numbers. I would say, I mean, it seems like a lot because we are in those types of hearings fairly frequently, but I would say no more than 50%. I think there's a lot of people who are successful in reunification, but I don't have hard numbers on that.
Mm-hmm.
And that's the goal of the process is reunification.
Yes, definitely. There are very limited rules under the statute of which we can stop making efforts to reunify the family, and very rarely do judges allow that. Cease efforts is what they call it. Mm-hmm. So our goal from day one, and even on those terminations right out of the gate, typically are reunification.
Could you describe what types of cases a judge would, or you would ask for, efforts not being made for reunification?
If they've abandoned their child, the argument would be it'd be futile to try and make efforts to reunify if they're not there. If they have a prior involuntary termination of parental rights or involuntary transfer of legal custody, the statute allows that as a basis to cease efforts. And the one we see most frequently, unfortunately, is the egregious harm, where they've committed a sufficient level of abuse that it meets statutory criteria, that the statutes basically say we won't make an effort with this parent.
All right. I've been given the high sign, so we're going to take a brief break here for a public service announcement, and we will be right back.
You still texting?
Is this a real morgue?
Yep.
Shut up. Like with real dead people. Ooh, I gotta text Ashley.
Ashley identified you when you wrapped your car around that light pole because you was caring more about that thing than the road.
I knew she liked me.
Not anymore.
There's a reason it's illegal to text and access the web while driving.
Really?
Buzz, what's up, man? You left some leaves burning out here.
Yeah, I just came in just for a second.
Come on, man. If it's too hot to touch, it's too hot to leave. You could torch the whole neighborhood.
It's a good point there, Smokey.
9 out of 10 wildfires are caused by humans.
Only you can prevent wildfires.
Here's to the things that can keep us safe. Those we use all the time with hardly a thought. Those that are silently standing by to save our lives. And now, those that we carry with us everywhere we go. Many mobile devices will now bring you wireless emergency alerts, real-time information directly from local sources you know and trust. With the unique sound and vibration, you'll be in the know wherever you are.
sun, tell him that I've begun to dream of things to come, and tell the trees not to look for me. I'm going to find some peace of mind. Wake the sun, wake the sun, wake the sun, wake the sun.
Welcome back to the District Court Show. The topic of our program today is Minnesota Child Protection. Our guests are Ann Zimmerman, an Anoka Assistant County Attorney, and Suzanne Tuttle, Supervisor in Social Work Department in Anoka County. Let's talk about once there has been at least a CHIPS adjudication, which means the children have been found to be in need of protection or services. What's the process from there, Ann?
Typically, we work towards a case plan if there's not already one that has been established. Social worker meets with both parents of the kid, whether or not the child has two custodial parents or one. They work with both parents. They determine what services are needed both for the child and the parent, and then they work with the family, and the real hard work begins, and my job steps back quite a bit, and they meet with those parents to get those services in place and then monitor their compliance.
And there's a lot of services, so Suzanne, could you kind of describe the more commonly ordered conditions and what those services are?
Of the court-ordered ones?
Yes.
I would say a parenting assessment, psychological assessment, in-home family therapy, or if the child's out of the home, it might be in-office therapy,
chemical dependency.
Meet with the social worker on a regular basis.
Visitation plans.
Oh yes, the visitation plans for sure.
And I think conflict is relatively frequent between the social worker and the parent that's all of a sudden got government in their lives. And talk a little bit about that.
I think initially there's a little bit of conflict because, of course, families are scared. You know, they love their children and they want the best for their children, and they initially, yes, they do not want us in their lives. So typically most of the conflict arises in the beginning with the investigator or the assessor. Once it's been through court and the new case manager for the longer term services has met with them, again, they recognize that they need services for their family. They recognize that they probably want services for their family. And if their child's out of the home, they want their child back. So they're pretty highly motivated. And we have great, very skilled social workers. They know how to engage families and build trust with them. And they're there to help those families, you know, get those services and make changes so that their children can return home and be safe.
And eventually there might be what's called a trial home visit. What's that about?
So a trial home visit is technically the child is still in the custody of the local social services agency, but the parent takes the child home and has all the day-to-day responsibilities for that child. But should something go south and it's not a successful return, social services can remove that child without further court order.
Talk a little bit about what's the involvement of the foster home, foster parents.
So a lot of our foster parents are very involved. Often they even assist in some parenting education on a level. But our foster parents in Anoka County are fantastic about assisting with visitation, maintaining a steady lifestyle for the child, making sure they get to their activities in school. Some even transport them out of a district so that they can maintain their schools. So our foster parents really, I mean, they probably have the hardest job of us all.
Absolutely.
Before break, Suzanne, you mentioned that there's a rise in petitions. And I'm wondering if you mentioned task force. So there's been a task force assigned to look into the child protection laws, make these recommendations. And there's been now some more budget money to hire more social workers.
Yes, they made 93 recommendations, which is a lot, but they also provided counties with money to address address staffing mostly. And so in Anoka County, we are in the process right now of hiring 11 new staff, mostly on the upfront part of the services. So we are hiring investigators, assessors. We're going to have a whole new screening unit with 4 screeners instead of 2, and a new screening supervisor, and then a few more social workers down the line, because we know that there's going to be more petitions and there's going to be more long-term services.
And then, Ann, how does that impact your office, or how does it impact other agencies such as Guardians ad litem?
Well, I think both offices are going to feel a strain. The legislature provided money solely for social services. The task force actually recommended that the money be given as a pool to each county so they could determine if more law enforcement were needed, more attorneys were needed, or more social workers. So I think both divisions are going to feel a strain, my office and the Guardian ad litems. I think also law enforcement is feeling the strain. The part of the change in the statutes was a mandatory cross-reporting. So law enforcement is now obtaining every single report that social services did, where in the past they typically only got that cross-reporting when it was appropriate for law enforcement to be equally involved.
Go ahead, I'm sorry.
I was just going to say, now there is no interpretation, it's mandatory.
What is the purpose of the cross-reporting? If law enforcement is getting this information as well, what are they to do with it now?
Well, the purpose is to make sure everybody knows what's going on so that at least one of the entities knows. So in the past, there was no cross-reporting mandated except for everyone was supposed to get social services the information. Now, by having everybody required to notify each other, everyone is involved and you have less likelihood that something slips through the cracks. If you're working voluntarily with a family, if law enforcement sends over a report that we didn't know about, then we can address that issue. And previously it might not have been known because it was relatively minor in law enforcement's opinion, but impacted that case.
Will this increase the number of visits a family will have to their home?
I think the change in the screening guidelines, the change the legislature has made based off the task force is to have a greater focus on child safety and child assessment for risk. So I think there are going to be more visits because the approach is better safe than sorry at this point when it comes to child safety. Whereas before it used to be family preservation and privacy, now it's child safety.
So there's been, and I noticed that there's been a shift in what the focus is in these reports. It's through the child's eyes, really, is the focus of everyone involved in these proceedings.
Correct.
Statutorily, it was, the focus was family engagement more. And now they've purposely changed the language to say that child safety is the priority. We would say that we've always, of course, believed that, and we have great social workers who are always engaging families and looking at the safety of the child. But it makes everything clear for everybody. There's an attempt to try to be much more consistent across the whole state. For counties, mostly follow statute, but every county, did things a little bit differently. So,
do you think that there's a trend toward focusing on kind of the rights and needs of the child as opposed to the rights of the parents? Because that's kind of happened in family law too, is that in determining custody, the 13 factors that have been around for 30 years, those were just modified too, and they took out number 1, which was the wishes of the parents. And it seems like the focus now is more towards what's best for the children as opposed to what do these parents want. Is that happening in child protection too?
I think that people who've been in the trenches, if you will, have always sort of had that thought process. I can't imagine how many times I have said it's not about you, it's about your child. But I think the focus here with these changes that the task force is doing, the increased communication, the ability to give information to mandated reporters who are going to be treating their health, education, or other specific needs, the ability to share information because it's for the best interest of the child, previously was viewed as a privacy violation or an invasion to that parent, and now it's not about the parent, it's about that child.
There is even an addition to the law when you consider kinship or relatives for placement. Now, kids or siblings of the same parent who had their rights, that parent having their rights terminated to that child can be considered for placement, or that home at least. So it seems as though siblings and the kids are more important now than the parents, it seems to me.
Right.
So
Well, siblings are typically the longest lifetime relationship that you have. So it's really important, of course, to preserve sibling relationships. And yeah, there's an emphasis on that if there's an adult sibling, that they would have the opportunity as well. And we talked about foster parents, how fantastic our foster parents are in Anoka County and everywhere, really, I'm sure. But also there is a focus on placing children with their relatives whenever possible. So we have increased that over the years when it's possible and safe, and we can do that.
And I'd mentioned off camera, you know, coming into the initial emergency protective care hearing, and the courtroom is filled because all of a sudden, you know, it is an emergency for this family because the children were taken from perhaps, you know, the 25-year-old, you know, mother and father and grandma and grandpa and aunts and uncles. They're filling the courtroom. Sometimes it's hostile, but oftentimes it's, here's the whole support network for these two that, you know, maybe they just made a bad mistake. They're both on meth, and maybe they need some severe chemical dependency help, but they do have this whole, you know, cloud of people that's going to help them through the process. How does that help make your job easier, your staff?
Well, if they all show up at the hearing, that is fantastic, we think, because one, like you said, all these people showed up that care about these kids and they want the best for these kids, and they may not have known the extent to which things had gone downhill. So now they're learning, and they want those parents to get their acts together and take care of these kids, so then we can meet them, introduce ourselves, talk about, you know, are they interested in caring for these children if they are ordered out of the home, and not only just caring for them, but also can they be involved in other ways? Can they be involved to support the parents? Can they be involved with these kids? And, you know, hopefully the family and the community then can be part of the safety plan.
One issue that I've seen in Wright County, which is somewhat similar to Anoka County, is the matter of transportation. I mean, we give them this placement, this case plan with these dozen of things they're supposed to do, and they may not have good transportation. At least in Anoka County, you've got the bus system, and we basically have almost nothing. That's a challenge for people, getting around to all these different doctors and therapists and everybody.
Yeah, it's definitely a challenge. We're part rural and part urban, so we do have some great bus system and some not so great in the northern part, but social workers and case aides are very, very helpful. They're always willing to help transport. And the extended family, that could be another thing that they could help out with.
Any final question? Beth?
just quickly, babies that are born with issues or have positive drug results, for example, is that what happens to those kids?
Typically, those immediately instigate and report to social services. Typically, it becomes an investigation. Then it's a matter of figuring out what kind of risk level and ongoing concerns there are for the child. Sometimes they test positive because they're on prescription meds that the hospital wasn't aware of, and that resolves the case. Other times, we're in court, and the child's removed.
Well, I want to thank both of our guests, Ann Zimmerman and Suzanne Tuttle. Very, very informative. Thank you for appearing as guests.
Thank you for having us.
If you have any questions, viewers, you can send me an email. We're going to run that in the credits here. So thank you for watching the District Court Show, and we'll see you again next time.